Channel.
It is now 2:20. We were delayed because of technical difficulties. Call this meeting to order. Mary, would you do the flag pledge?
Sure. All rise, please. Place your hand over your heart. Ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, will you do the roll call, please?
Councilmember Aaron Kranz.
Here.
Councilmember Green.
Here.
Mayor Pro Tem Smith.
Here.
Councilmember Welty.
Here.
Mayor Castillo.
Here.
All present.
Mr. City Manager, are there any changes to the City Council agenda?
No changes.
Need a motion and a second to approve the agenda.
So moved.
Second.
Roll call vote.
Councilmember Aaron Kranz.
Aye.
Councilmember Green.
Aye.
Mayor Pro Tem Smith.
Aye.
Councilmember Welty.
Here.
Mayor, thank you. Mayor Castillo.
Aye.
Motion carried to approve the agenda.
Any public comments?
We have no public comments, but I'd like to remind the public that we are accepting comments via email. Please send your email to publiccomment@canyonlakeca.gov.
Okay, and now we have a presentation on the Brown Act by our city attorney.
Thank you, Madam Mayor. Members of the City Council, thank you so much once again for this opportunity to go over the Brown Act, and then to follow this, we'll be going over mandatory AB 1234 training. The Brown Act training is actually a part of the AB 1234 training, but we usually separate it out here just because this is where a majority of questions from both the public and from the council seem to originate. You'll recall I did do this training, I think about a year and a half ago, and there are some updates to the Brown Act that I will cover at the end, called out specifically, but we are going to be going through the entirety of the presentation that we have gone through before, because we do have new council members as part of the body. So please give me a second here. We'll move on to the next slide. So just to give everybody an overview of the topics that we'll be covering as it relates to the Brown Act, we're going to be talking about the background and the history of the Brown Act. First off, by answering the question, what is the Brown Act? Then we're going to be talking about meetings. What is a meeting? What's not a meeting? And how we need to conduct those meetings. Third, we'll be talking about agendas and notice, which is a very important part of the Brown Act. Agendas inform the public as to what business is going to be discussed, so the public can be informed as to whether they want to attend or not. We'll be covering closed sessions. These are the portions of public meetings which are closed to the public and held only by the city council and necessary staff. And then finally, we will be talking about enforcement. What happens, if a jurisdiction happens to run afoul of the Brown Act, how those issues can be cured, and any other remedies that are available to the public. And then lastly, it's not here on the overview, but there are a couple of updates to the Brown Act, one of which I know that Councilmember Aaron Krantz had a good article on that I used to help with the presentation, related to recent changes in the law pertaining to social media and how the city council should conduct itself when conducting the public's business in that arena. I do have to put this disclaimer up here. I'm obligated to by my firm. The following presentation is designed to give an overview of the Brown Act and should be read as a general guide. This is not legal advice. This is a presentation where we're discussing the Brown Act. Any city officials who have specific questions should contact the city attorney's office. Anyone else should consult their own attorney. So, background and history. First question. What is the Brown Act? So people who are in government service know what the Brown Act is. The Brown Act is a state law that establishes the procedural framework for how the city council and other local agencies make decisions in an open way, how they debate in an open way, how they involve the public, how they inform the public of what is going to be discussed. And it's designed with the principal purpose of informing the public about what's going to be discussed and how, what are the particulars of the deliberations. A lot of people ask why, and I always just default to the language of the Brown Act itself. The Brown Act was passed in the mid-20th century to combat the appearance and perhaps the actual, occurrence of backroom deals, of last-minute meetings being called. The public didn't know what was going to be discussed at a meeting. They didn't know what the decision-making process was, and they didn't know what the results were. So the state of California passed this law, and in doing so, they said, the people of this state do not yield their sovereignty to the agencies which serve them. The people, in delegating authority, do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. And so I think if we keep that in mind as we go through this training and we let it guide us, I have found 9 times out of 10, even though the Brown Act and the other government ethics laws can be a little intricate, if you follow the overriding sort of purpose, you will get to the right spot most of the time. I wanted to put the new photos in the PowerPoint because I thought they looked so well done. So congratulations, City Council, City staff. Who does the Brown Act cover? It covers you. The language of the training is aimed at you, but it is also applicable to any advisory and standing subcommittees created by the city. So most of the city's subcommittees are staffed by the city council members themselves. But, this city and a lot of other cities have the capability of creating bodies that have public participation, members of the public on them. They are subject to the Brown Act as well if they are part of one of those committees that you create. Although, perhaps a little late for our newest council person, just so you know, individuals are subject to the Brown Act upon their appointment or election, even if they have not formally assumed office. So the typical advice is election night, you should start following the Brown Act, even though the election hasn't necessarily been certified. So that's basically the background of the Brown Act. Does anyone have any questions or want to make any statements, just to liven it up so I'm not talking at you for 3 hours?
I'm scared.
Do it.
Okay, so if, I don't need this, do I need this? Okay, so in the situation of a non-elected individual running for office and they meet with 2 elected individual and they have conversation, that's, how has that been?
So traditionally the view has been that if you are not elected or appointed to the office, you are perfectly competent to meet with other people.
Even as a candidate running for that office?
Even as a candidate running for the office. And in fact, it's very common. I mean, people want to know where you stand on issues. It's expected that you will tell people how you view them. But I think once you become to the point where your election is reasonably certain, at that point you become subject to the Brown Act and you need to start following the scriptures. So after election, or election night and afterwards, is usually the line I would draw. Yeah. Okay. Thank you for breaking it up, Mayor Pro Tem. So section 2, we'll talk about meetings and conduct. I think we all have in our head a definition of what a meeting is, right? And this is the danger of using the English language when writing laws. But there is a very specific definition that is in the Brown Act. What is a meeting? A meeting, for the purposes of the Brown Act, is when a majority of the council are present at the same time and place to hear, discuss, or deliberate the business of the council. So I just want to break that down just a little bit, because although this change has been around for a while, this still was something that was changed probably about 5-6 years ago and is different than it used to be. When you look at what it says here, hear, discuss, deliberate, there used to be a practice in some cities, not this one as far as I'm aware, of having council member briefings that would occur before meetings, where you would have 3, 4, or the full council present. They would not talk amongst themselves, but staff would come in and basically give them as a body the presentations that were going to be shown to the public later. So if you look at this definition, a majority of the council to hear the business of the council. So we can't do that anymore. Public agencies can't do that anymore, and they don't. Discuss or deliberate, right? So obviously hearing, I mean, that's probably the lowest version. You're not even talking back to the person. But discussing amongst yourselves, discussing back to staff where other council members can hear you, or deliberating, which is what you do typically where you hear things and you talk amongst yourselves about whether it's a good idea or not. Same time and place. You know, we do get a lot of questions. People read this literally. This includes the use of technology. So we have a council member on the phone right now. We have been using a lot of technology during COVID to do the business of the city. Same time and place means if we're on the same call, if we're on the same Zoom meeting, if we're on the same email chain, right? And so you'll notice that, you know, some cities will get status reports from executive level staff like the city manager, and it will usually say, do not reply to all when you got this email. Because although information can go one way, and we'll talk about that in a few minutes, in those contexts, you can't reply to all because that would be essentially the definition of a meeting.
Can I ask a question?
Absolutely.
In an emergency situation, which you don't have time to do postings and everything else, but you need to confer with your councilman, this Brown Act does not apply to that, correct? So
the Brown Act applies all the time. There is an exception for emergencies, and I will absolutely get there.
Okay.
Yeah. But good point. You know, I mean, I got to tell you, you know, last year in March and April, unprecedented in public service to have. I mean, you know, we had public emergencies before, usually defined in time and place. It's very unusual to have this long-term massive emergency that just keeps rolling in. And I think a lot of cities became very familiar with some of these provisions that existed. But yeah, we'll be going into that. Yeah. So what is not a meeting? So one of the biggest ones are conferences, trainings, and workshops. Now, it doesn't include this training because what I did not put here are conferences, trainings, workshops put on by someone other than the public agency itself. So I guess I should put that caveat there. But, you know, League of California Cities, I mean, you get a lot of public officials in one area. It's not unusual to see more than a quorum of city council members from a particular agency or the boards of a particular district at one of these conferences or trainings. As long as it's not being put up by this agency, just because there's 3 or more of you present at the conference doesn't mean that it is a prohibited meeting. That being said, the 3 or more of you cannot, you know, get together at the conference to discuss the business of the city under the guise of the conference, right? So that would be almost like a meeting within a meeting, right? I hear another question coming on.
Those are after-hour discussions.
Sure, you know, and I think that, you know, it's very common, you know, that there will be perhaps socializing. Social occasions are one of the exceptions, again. But I would just say that, you know, be very cautious. And in addition to the legal definition of what is or isn't a meeting, one of the things I always advise is be very cognizant of the appearance, right? So, you know, even though 3 council members may be within an exception to the Brown Act's meeting requirement, doesn't mean that a member of the public who sees 3 council members at a conference talking amongst each other might not get the feeling, oh, you know, they're discussing the business of the city. So, you know, be cognizant of it, and I think that will serve you well. Prohibited meetings. So we talked about this very briefly, but this is the use of technology. And so you'll notice this has been written and then updated later. I would very much like to see this council attempt to have a meeting by fax machine. I used a fax machine just the other day. Fantastic. But it was put in the ordinance and then they've been adding to it as technology has gone along, right? So they started with telephones and then they added council member C didn't even know who B had spoken with before. They had no idea that this was potentially an issue. It's very easy to fall into that trap. So one of the most common questions that I advise council members to ask their colleagues if they're about to discuss a matter is, who else have you spoken with about this topic, right? And that way, I know, if I'm a council member or you're a council member, if you've already talked to too many people, or if I've already talked to too many people, then we're avoiding the serial meeting issue. I know that can be a little crazy when we do like the connecting the dots, but does anyone have any particular questions about that one? That's just like, that's the one I get the most questions on. That's why I always bring it up. Sounds good? All right.
Who's going to be aware of that situation? You have to turn yourself in?
So what we'll get to that, and that really addresses the underlying issue, which is, having discussions that the public can't participate in, right? So if we have an issue, let's bring it, make sure we put it on the agenda and have a discussion of it.
So if you had this serial meeting and you decided that it's a good idea to put it on the agenda, what happens to them that you had this meeting? Is that just forgiven, forgotten?
Well, we'll certainly talk about exactly what the process is under the Brown Act for it. But the Brown Act is not written to be overly punitive, in my opinion, unless you are purposely and intentionally transgressing it. The Brown Act understands that we are people, and some of these, like I said, this one with the serial meeting, you can walk into that and didn't even know you were walking into it. The purpose is not to punish you if you have an issue like that. The purpose would be to bring the public into the conversation so that they can participate. Yeah.
Mr. Attorney, if I can just remind the council to please speak into the microphones and make sure your microphones are on. We have our guests on the phone, and just for the people watching at home, it's kind of hard to hear with the masks on already, so it's important to speak into the mics and just make sure your mics are on, please. Thank you.
Sorry.
It's okay, thank you.
Speaking of involving the public, thank you, Madam City Clerk. All right, so moving on. Acceptable communications. So the following are not prohibited by the Brown Act. Attorney-client communications. So we'll talk about closed sessions. You're familiar with those generally. Those are portions of the meetings which are closed to the public so that we can confer as attorney and client. But also attorney-client memorandums that I sent. They're already privileged, but they're also just not subject to the Brown Act. One-way communication by staff to individual council members. So this is, like I said, how, this frankly is usually going to come from the city manager. City manager is perfectly entitled to communicate with each of you on an individual basis, or two of you at a time, to brief you. And usually that takes the form of status emails, perhaps from a city manager, or meetings that he sets with you. And then lastly, individual contacts by council members with constituents, staff, consultants, or colleagues. So, you're allowed to take meetings with your constituents. Just because your constituent met with other council members doesn't mean you are not allowed to talk with them. The thing that I would encourage you to let them know is, don't tell me what you talked about with another council member. You talk to me, tell me your concerns, I'll tell you my concerns. And that's perfectly all right. Speaking of the public, where does the public fit on the agenda? This is the people's business. So first off, meetings must be accessible to the public. And we'll get into later some of the modifications we've had to make for COVID, which strongly discourages, in-person contact. Typically, the way you make meetings accessible to the public is you have half of a room devoted to their use during your meetings, right? For now, we broadcast it in a variety of different means, and the city clerk takes in their comments electronically. The meeting must usually be held in a location within the city. There are a couple of very defined exceptions to that, which aren't, typically utilized. But we can't, for example, have the city council of the city of Canyon Lake go meet in Paris, right? Unless we met one of those exemptions. The meeting must be held in an ADA accessible location. All of the public needs to be capable of coming to our meetings, and it's certainly something that staff keeps an eye on, making sure that we are accessible here. And then the last one, this one's always interesting because, and you look at sort of, we want to know when people bring up issues, we'd like to know how to contact them so that we can get back to them. When we're doing public hearings, we'd like to know who's testifying so we have a good record. But just as a legal matter, we cannot require someone identify themselves. We can request it, certainly. But if someone says, I would prefer to remain anonymous, we have to honor that. Anonymous participation in democracy has a pretty strong foundation in this country. I'm thinking along the lines of pamphlets and newsletters written during our country's founding, things like that. So this one, identify themselves, has also come up in neighboring jurisdictions. Harupa Valley, a couple of years ago, had a gentleman who would go to city council meetings wearing a mask that obscured his face. He went by the name Anonymous. And he would go and he'd make his public comments, but he didn't want to be identified when he went to city council meetings. And this caused some concern. There was a security concern. Who's this person at our meetings? And ultimately, that city council, after weighing it, realized, we do need to let him participate, so long as he's not a threat or a danger. Infamous, that was his name, not Anonymous. Let's see, the meetings must involve the public. Restrictions on public comment must be reasonable and may include time limits. Our city council here has adopted city council protocols that include reasonable time limits. As much as we may want to, we cannot prohibit the criticism of the city. We have to allow anyone who wants to come and complain. This is their democratic right. Complaining about the city and criticizing the city is welcome. This is another one that has come up a couple of times where people get maybe a little concerned. The public is permitted to record and broadcast the meeting. So if they want to stand in the back and have their phone up and record it, if the press wants to come and set up perhaps more professional cameras, as long as they are not disrupting the meeting through the recording, they are permitted to do so. And the public must have access to copies of all backup material. The practice of this city, obviously, is to make the backup material available online days in advance, which is more than the Brown Act requires. Every now and then we may have a matter that comes up urgently and we don't have time to put the backup material online, so it is provided at the time of the meeting. But we do need to make sure that the public has access to all the materials that you have access to. In fact, when a document that is not otherwise privileged is given to 3 or more of you, it immediately becomes a public record under the Public Records Act and has to be disclosed.
On time limits, we've obviously got a policy. What happens if a city is loose in that enforcement of that policy that allow one speaker to speak 5 minutes, one speaker to hold him to? Can we be held accountable for that? Inconsistency?
That's a really good question. So it's really going to come down to a couple of different factors, right? I wish I could just give you a yes or no. I would say that there is a concern that's raised when it appears that one speaker is given more liberties when addressing the council. Perhaps it is indicative that their viewpoint is preferred by the city council. But I've also seen other examples where it's perfectly reasonable to give perhaps one person more time. And I'll give you an example. It's very common in public hearings on zoning matters to hold members of the public to a 3-minute or 5-minute rule, maybe so they can process them, but to give the applicant, right, as much time as they need to make their presentation. Because it's only fair, this is their project, and they have to respond to 20 different people, that they should be given adequate time. And so I think that it's the kind of thing that, we want to be fair. You don't want to give the appearance that you're playing favorites or that you prefer certain viewpoints. But on the other hand, there are certainly examples where it's perfectly reasonable to make a distinction. All right, so let's talk about the types of meetings. So regular meeting, this is, I was about to say, a regular meeting is, your regular meeting. The regular meeting is the meeting that occurs at the time and place set by resolution or ordinance. For this city council, it is the first Wednesday of every month. A regular meeting can cover any topic within the subject matter jurisdiction of the city council and is required to include public comment for items not on the agenda. In addition, we'll get to agenda posting in a bit, but regular meetings have to be posted at least 72 hours in advance. Special meetings, on the other hand, occur as any other meeting that isn't the regular meeting, and this includes emergency meetings, to Councilmember Green's earlier question. These are oftentimes set on days separate from the first Wednesday of the month, and you could perhaps have a goal-setting workshop, very common, a budget workshop, typically used to discuss a matter of significant importance where you want to give that particular item its due time for deliberation. You don't want the other business of the city to take away from it, or perhaps to accommodate greater public input, maybe doing it on a different day or at a different time, or even to perhaps give a more informal opportunity to invite the public in for additional comment. Like I said, typically I've seen this with budgets and with goal setting, but it could cover any other number. If there's a particularly controversial topic, perhaps you don't want your regular meeting to, I don't want to say get hijacked, but to essentially be overrun by one particular issue. You want to be able to continue the business of the city. And so maybe you'll set the controversial issue for maybe the following Wednesday. A special meeting may cover any item within the subject matter jurisdiction, does not need to include public comment for items not on the agenda. However, it is the practice of this city to include that anyway, just in case members of the public do have, because they're not always going to appreciate that distinction. They want to be able to talk, and I think this council is wise to allow that. This doesn't come up, but occasionally you will find that you run out of time for a particular meeting, and so you want to adjourn that meeting to another day. And so there is adjourned regular meetings. So you could have your regular meeting on the first Wednesday, and after going till midnight, the mayor could say, look, we still have to finish this stuff, but I'm beat. Everyone's beat. The public needs to be able to go to sleep. So we're going to adjourn this meeting until 6 p.m. tomorrow, right? And so that meeting the next day, even though it's not on your normal day, would be an adjourned regular meeting because it's a continuation of that regular meeting. You can do the same thing with special meetings too. It's not super important except for it imposes specific notice requirements for the clerk. She has to post special things when these things happen. Speaking of posting things, we're into section 3, agendas. This is my favorite part because this is where I get to work with the city clerk. And we get to come up with the amazing agenda that informs the public of the topics to be discussed at the city council meeting. And just before we start, like I said, I keep that in mind. Like, what is the purpose of an agenda, right? Obviously, there's an important purpose for the city council,
I
right?
got one question.
Yes, sir.
before we move on to agendas in regards to the repercussions of breaking the Brown Act?
Yes,
Other than recall, what is there?
other than recall, the repercussions for violation of the Brown Act.
Uh-huh.
I have a whole section on what
Got it,
happens to
thank
when you
you.
violate the Brown Act. We'll get there, trust me. I try to do all the fun stuff first and then the scary stuff at the end. Oh, that can be the fun stuff too, I guess, depending on your point of view. So the purpose, again, of the agenda for the public is to inform them of what's going on at the city. And so, if we're looking at different questions, we get a lot of different questions about agendas. If we recognize that the essential purpose of the agenda is to inform the public of what's going on, usually we can find the answer to our question, right? So one of the questions is, that it's not specifically covered in this slide, but something I get a lot on is agenda item descriptions. What is an adequate description of an item for an agenda item? And if you look at it from the perspective of city staff or the city council, we deal with this stuff all the time. We can write a very short description and it could be highly technical. And we would all know exactly what it is, but perhaps a member of the public might have difficulty. And so, that's why it's usually very important to say, what is it we're being discussed? And city staff is very good at writing those agenda descriptions in that way so that a member of the public understands what's going on. Notice of the meeting is given by the posted agenda. The agenda is posted in a public place on the city's website and mailed to persons who request notice. Madam City Clerk, not to put you on the spot, but where do we currently post this city's agendas?
We have a bulletin board outside. We post on the city's website, and we also post at the Pack Wrap and Post. We also email it to our city council agenda distribution list, so we don't have anybody that requests physical copies to be mailed to them, but they do request email versions, so we do have a list of people.
Fantastic. And that kind of makes sense only because the amount of time it takes to get something in the physical mail, the meeting might have already come and gone. So an email distribution list is fantastic.
And we also post on Facebook.
Very good. So all those listening, those are all the different ways that you can find this city's agendas, if you're interested in knowing what the city council is going to be talking about. So what kind of notice is required? So for regular meetings, we already talked about it. Agendas must be posted at least 72 hours in advance. An adjourned meeting, when a meeting is adjourned, it is adjourned to the time and place specified in the order of adjournment. So that's when the mayor says we will be meeting at date, time, place. The city clerk will turn that into an order of adjournment to be signed by the mayor. If it's adjourned for less than 5 days, all we do is we post the order of adjournment. So it'll say the regular meeting, the special meeting of January 25th, 2021 is hereby ordered adjourned to January 26th at 6 p.m. in the city council chambers, right? If it's going to be longer than that, then we do have to repost the agenda itself. Special meetings, these need to be posted 24 hours in advance, not 72, and delivered to each council member and each member of the press who has requested notice. So this comes to the question from Councilmember Green earlier about emergencies. So an emergency meeting isn't its own type of meeting. There's no such thing as an emergency meeting. There is a special meeting where the city council has found that the notice requirements should be waived because of a natural disaster, terrorist attack, work stoppage, other crippling activity. And in that case, we do want to give 1 hour notice to everyone that we can, if practical. But all that is it's just a special meeting where we made a specific finding that we did not have to wait 24 hours because of the importance.
Because
Some councils in that setting, in their emergency operations, their council is their disaster council to decide policy, to help guide policy of the jurisdiction as that jurisdiction is impacted, plus the region.
Absolutely.
So that's why I was trying to get the distinction, if in fact that latitude is allowed us, because sometimes you're not going to be waiting 24 hours to call call for help or whatever else has got to be decided.
And my understanding is that your city clerk's office has also worked on putting together all the documents you would need to hold an emergency city council meeting, including resolutions issuing purchasing authority, declaring disasters, so that you can in fact do that, and that's very common.
Okay.
Non-agenda items. So this is something that unfortunately, when we have constituents who come to city council meetings and they have a concern, oftentimes they are dismayed that they cannot simply come to the city council and say, I have this problem, city council. What say you? Can you solve it? And unfortunately, it usually falls to the mayor to inform the member of the public that because of these transparency issues that we have, or these transparency laws that we have, we cannot discuss your item because it's not on the agenda. Unless an emergency situation exists, as we talked about. 2/3 of the council member present determine there's an immediate need to take action, and the need came to the attention of the city subsequent to the agenda being posted. Or when the item appeared on agenda for an adjourned meeting from less than 5 days prior, right? That's the order of adjournment issue that we talked about earlier. Going to the 2/3 thing, I want to bring that one up, because that one comes up, not in this city, because you guys are fairly well managed.
Thank you.
Yeah. Adjourned. Fairly well managed, if I do say so. In my own opinion. That's fine. I don't want any. It's a privilege to serve. But if we say here, came to the attention of the city subsequent to the agenda being posted, not of the city council, right? And so oftentimes what we'll find is that a member of city staff, usually in bigger organizations that have layers of bureaucracy, lower level staff knew about the issue. It just maybe didn't come to the city manager's attention or the city council's attention in time to be on the agenda. And unfortunately, that's not good enough. If staff knew it was an issue, then the city knew it was an issue. And this justification doesn't exist. Non-agenda, going back to what I was talking about earlier, maybe I jumped the gun a bit. Members of the council and staff may briefly respond to comments or questions from the public during public comment, even though the item is not on the agenda, and they may direct those issues to staff to be looked into, maybe provide some brief factual information, or refer to a future agenda. But we can't have a full-blown discussion about it. If someone comes in and says, City Council, I've got a real problem with, the lack of speed bumps along my street, and I demand that the city council take a vote now to order the city staff to put speed bumps in front of my house. We simply can't do it as a city. You need these transparency protections exist for everyone's benefit. And although it's a burden that kind of falls on the city attorney to assist the city council in seeing that that line exists and maybe it's being crossed. And to recommend perhaps, we stick to the merits of agendizing it as opposed to the merits of the project or idea itself. We do place on our agenda future agenda items, so that is something that City Council can certainly discuss whether they want to place a certain item on the agenda or not. But you're right, we do need to be careful not to fall into the trap of, in deciding whether to talk about it, we end up just talking about it. Closed sessions. So for everyone who's not familiar with what a closed session is, a closed session is essentially a portion of the public body's meeting or city council meeting where the city council excludes members of the public and non-essential staff so that the city council can deliberate on a very few specified types of business, which for public policy reasons have to remain confidential. One of the ones that we will discuss almost immediately is litigation, but just to give you an example, if we're discussing the settlement of a case and how much the city is willing to perhaps spend to settle a case, it would be very difficult for the city to engage in that negotiation if the other party could sit in the audience and find out exactly where the city's negotiation position was, or if they could hear my legal advice to the city council on the strength of a case. The city needs to be able to have those kind of discussions. Same thing with real property negotiations. If the other party knows how much the city council values a property and is willing to pay for it, why would they accept anything less? But the public interest is in getting the property at the lowest price for the city. So while the Brown Act strongly favors discussion and action in open, there are specific circumstances that can take place in closed session. And it usually will include the city attorney, city clerk, city manager, council members, and any other staff which are necessary for that discussion. There are very specific agenda requirements for under the Brown Act for closed session items. There's even a section in the Brown Act, 54956.5, I think, or 54.5. I don't know it off the top of my head. I think it's 5.4, that specifically lists exactly the language that the city clerk should use on those sections, and she follows it. It's a fill-in-the-blank sample language. Following the closed session, there are certain items that the city attorney is required to report out, and you'll notice that I'm on every agenda after closed session, city attorney report, and I am required to report that out. Minutes and recordings are not required for closed session because the intent, again, is to have those frank, confidential conversations regarding those select matters. Litigation is probably the most obvious one. Allows the city to avoid revealing confidential information that would prejudice the city in negotiations and legal proceedings. Different kinds. So existing litigation is the obvious one. The city has been sued. Or the city has sued someone else, and a lawsuit exists. So we're going to talk about that case, and we are going to agendize it. The exact case we're going to talk about is going to be on the agenda, so everyone knows we're talking about that case. Sometimes the city council receives updates. Sometimes we develop legal strategies, and I get direction. Sometimes we discuss settling a case, including the approval of a written settlement demand. Initiation of litigation, these are the other two types. So this is where the city council may discuss whether they want to initiate a litigation or to sue someone else, right? And you want to get legal advice on whether that's a good idea or not. What is the strength of our case? What are the weaknesses of our case? How much is this going to cost the taxpayer? And then significant exposure to litigation is the reverse side of that. That's when we think the city may be sued because there are specific facts and circumstances that exist that we can look at and point to and say, these facts and circumstances indicate that our jurisdiction is likely to be sued. And we want to talk about that. This one, under initiation and significant exposure, the reason I group them together is because under both of them, the city may or may not publicly disclose who they're planning on suing. You don't always want to tell the other party that, hey, a lawsuit's coming your way, if it would prejudice the city. Same thing on the significant exposure. Maybe we know certain facts and circumstances that could lead to litigation or liability, but maybe the other party doesn't know. If we list all those facts on our agenda, well, we've just made it a lot easier for the city to get sued. Other issues, public employment. So this is the personnel exception. Your city attorney was on the agenda under personnel not a few months ago. Your city manager occasionally gets on for his personnel evaluations or contract negotiations. And this is primarily to protect the privacy of the personnel who are being discussed. Although we are public servants, we still have feelings. And nobody wants their personnel evaluation to be streamed live. And it also allows the city council to be, I think, frank with those personnel. Here's the issues that we want to see as a council for the betterment of our city. And then finally, it allows the city council to have frank discussions amongst themselves regarding the performance and perhaps future appointment or dismissal of a public official, so that the city business can be done. confidentiality of closed sessions. So this is probably one of the issues that comes up in a fair number of cities, not so much in this one. And I'll tell you, it's not the litigation that's really a problem. You usually know when any problems on the other side, or it's not public employment in the sense of a city manager, city attorney. But sometimes you have labor negotiations. A lot of people are very interested in knowing what's going on. There's a lot of pressure to find out what's going on. And so it's just important that the city council and all public bodies know that the Brown Act prohibits the disclosure of confidential information. It's acquired in closed session by any person, not just the council, by also staff. That information is privileged. And closed session privilege is a privilege that I've cited before. Violations can result in disciplinary action against an employee, censure if it's one of your colleagues on the council. Councils have censured members, removed that member from committee assignments or positions on other boards, and can even result in the referral of a member of the council to the grand jury, if in particularly egregious cases. Because remember, you can't keep the council member out of the closed session. So, if you have a problem with a person, there's very few ways you can resolve it in that case. Speaking of resolving issues, we get to the last section, enforcement, the Mayor Pro Tem's favorite section. So, getting on to enforcement. So, civil enforcement and cure demands. So, if the council acts in a manner that is perceived to be in violation of the Brown Act, the district attorney or any interested person may seek a determination that the action is improper, okay? AKA, they can sue the city for a determination. But before they can sue the city, they have to send a letter to the city that says, here's what you did, here's why it violated the Brown Act, and I want you to fix it. And the city council can place that on a future agenda, place the item, can have a discussion about it, and can essentially cure the defect by complying with the Brown Act, by having a noticed public discussion about it. So, it's very rare. There is Brown Act litigation, it does exist, but as a practical matter, the Brown Act is not designed to incentivize a bunch of litigation. So you find most cities, including this one, don't have Brown Act litigation. Because in the rare time when you may have someone who says, you guys did something wrong, it's very easy for the city council to cure that issue and invite the public into that discussion. I'll give you a couple of examples of cities that did want to litigate it. That would include the city of San Diego, which wanted to hold very broad discussions under the Brown Act closed session provisions for real property negotiations when they were talking about their downtown stadiums. So Brown Act says price and terms of payment. So you need to be talking about the price, the terms of payment. You need to have a nexus to that, a strong nexus. And the city council in San Diego, they wanted to talk about much more, right? Well, if we're selling this property buying this property or selling this property for use as a stadium, we want to talk about employment. We want to talk about, agreements with the city. We want to talk about the public benefits that this is going to have. We want to have a conversation about the wisdom of this deal instead of talking about the things that the Brown Act specifically says we can talk about. And they got a lot of city attorneys, I think, disagreed with the court's decision on that, and I did too. But, they fought it, and they got an adverse ruling that says, no, you talked about too much. Criminal enforcement. So, if the civil side doesn't work, if a member of the council participates in an improper action of the Brown Act with wrongful intent to deprive the public of information, then that is a criminal misdemeanor. So I feel like this is very difficult. I have found only one instance where a district attorney decided to take city council members to task. And that was a city council that had 3 members that were politically aligned with each other, who before every city council meeting met at the mayor's house to go over the agenda and talks amongst themselves about what they were going to do at the meeting. And here's the thing, they were called on it, and they said, okay, we'll stop. And then they kept doing it. They just moved it to the Mayor Pro Tem's house. And so the thing is, at that point, you have an obvious problem, right? It's not an accident. It isn't something that you can cure. You have people who are clearly intending to violate the Brown Act, and the DA went after them. I believe they all settled, and they agreed to give up their government positions and never hold public office again. So, conclusion. Brown Act. I did want to put the recent updates in here, as promised. The first one is the current COVID-19 modifications. These are things that we're all familiar with by now, but this was a conversation that was unprecedented. I remember back in March and April, people were saying, the state and federal government is saying, you cannot have people who aren't from the same household in the same room. How are we going to comply with the Brown Act, which requires it? And the governor issued multiple executive orders, but the one in particular was N29-20, which suspended, during the pendency of the COVID pandemic, the requirement for in-person participation by the public, so long as an alternative technological means is available that allows the public to view in real time and allows the public to participate. And that is what this city does. It, in fact, goes above and beyond by allowing multiple avenues to view the meeting and multiple avenues to receive the comment and participate. Some jurisdictions have opted to go with a single method, but this city has obviously gone a little bit broader than that. But just to comment on the technological difficulties we had today, we're obligated to provide that. If you have a technological reason that prevents us from allowing members of the public to view the meeting, then we are not in compliance, and that's an important way to get through this COVID pandemic until we can invite the public back in to the room. Your seats is being kept warm, and we welcome you back when we can. The other one, and this was a very recent change that was, I know Councilmember Ehrenkrantz had pointed out during one of his summaries on recent meetings that he had, was AB 992. And so this is the attempt for the California State Legislature to address technology that was developed in 2007, social media technology. And essentially what they're looking at is how should council members interact with each other and the public on social media. And first of all, the law encourages that behavior because the law recognizes that so much of our public discourse occurs online and occurs on social media platforms. So I want to say, before we talk about the particular requirement here, that in no way does it discourage that kind of behavior. Council members are encouraged to reach out to members of the public in that way. But what they did see was some troubling behavior in some jurisdictions. So one, it would not surprise you to learn that a lot of jurisdictions have closed groups which are available only to members of that community, right? And so, one of the things they wanted to make sure was that meetings were not occurring in these areas. So the first thing is just be mindful that a quorum or a majority cannot communicate using this channel of communication any more than you can anything else. But the biggest change that they made is, regardless of whether it's a majority or not, no member of the council, right, may respond directly to any communication on a social media platform from another member. So that's two people. So ordinarily, if you had asked me before this law was passed, hey, city attorney, the mayor has written a wonderful message to the community. Can I push the like button on it? I would have said, sure, like it. You can't anymore. You can't like it. You can't retweet it. You can't respond to it and say, great message. You can read it. You can read it, but you got to move on.
What about someone
And this happens. What about if someone is making a statement, a citizen's making a statement about a situation that is actually not factual? It is inaccurate, and it's spreading inaccuracies throughout the community. A council member, mayor, or whomever responds and says, unfortunately, that is not correct. This is what we're working on. This is why we're working on it, blah, blah, blah. And
Sure.
council member B says, and yes, and also we are doing that. Is that prohibited?
It's a good question.
Because
So-
it happens in small communities. We've got every kind of network out there, and there's a lot of people that send a lot of disinformation out constantly, either in the form of mistruths or just uninformed. Let's go the uninformed.
Sure. First of all, I'm shocked to find misinformation on a social media platform. And it, like I said, the legislature recognizes that in the 21st century, council members have a unique obligation, or opportunity, I should say, but you could say it is an obligation, to interact with their constituents in a social media platform. And that means, just as it means, if 50 years ago, if someone wrote a letter to the editor saying a bunch of information that's untrue, perhaps you'd feel obligated to respond, right? I think that there is absolutely no issue at all with you have information that's being circulated, having council members respond to that post and say, no, here's the factual information, okay?
Okay.
Here's where I say be cautious. You said then another council member comes along and says, yes, that, but also this, okay?
Yeah.
I feel like in typing that, you are in a way responding to the other person, okay? And the new language prohibits response to another council member. Now, can you respond to the constituent? Yes, you can, okay? Do not respond to the other council person.
Okay, but what I was referring to is not referring to the council person that responded, but also to support the council persons who responded based on additional information that would add more light, let's say, to the situation, or say that, yeah, we've crossed this bridge before, this is why.
Sure. What I would recommend is do not acknowledge in any way what the other council member said. Only because it gives the appearance that you're responding to them, right? Because here's the thing, if you say, in addition to what council member so-and-so said, here are some additional facts, right? Okay.
Okay.
What that does is that is responding in a supportive way, in my view. But if all you said was, here are some additional facts that you may not be aware of, if you just cut that first part out, right? If you say, you know what, here are some additional facts that you may need to be aware of, I see no problem with it.
Okay.
Mr. City Attorney, if I may.
Yes, of course.
So I'm Councilmember A. I'm going to take AB 992 so seriously that I'm going to go home and defriend all my colleagues on Facebook. We then find ourselves on a community page where our city manager is friends with all of us, and he sees a post from a constituent about a flood issues that we have and tags all the council members in wanting a response. I then go ahead and respond to that. Councilman B goes ahead and responds to that. Happens to be somewhat of the same response because we have the same information, because our source is coming from thus our city manager. How does that look upon this new AB 992 in that regards?
For the record, I never tag anyone ever.
That's good. You're not the one tagging, it's someone that
Don't
in the
add-
community that's tagging, but you're friends with all of us, so you see all of our response on that particular post. But I don't know what Councilman B said because I'm not friends with that person, and therefore, we're responding.
It's an interesting question, and I think the fact of the matter is that we are going to have to figure some of this out as we go along. But I'll tell you what my gut says, right? And I go back to what I said earlier, right? Look at the intent, follow the intent. the legislature clearly understands that communicating with your constituents is a good thing and a part of your job. So I would say, so long as you're talking to your constituents and not to each other, right, you're doing the right thing, okay? Be careful of communicating with each other by liking each other's posts, replying to each other's posts, mentioning each other, adding each other. Not that you did it, but now I feel like you've done it.
Done what?
Tagged everybody. But so I would say that, like, in those ways, don't talk to each other. Talk to the public, right? Talk to each other in the notice public meeting. So those are the updates. And then in conclusion, criminal enforcement in closed session. I don't know why I titled it criminal enforcement in closed session. I think that was a typo.
No, because you knew I was going to ask this question.
I wanted to end on a bang. So, members of the council, again, going back to the point, the purpose of being on the city council is to do the people's business, right? And the people want that business done in an open and transparent way. And as long as we keep our eyes on that, I think we are doing a pretty good job. Any questions on the Brown Act portion of our AB 1234 training before we switch to the much more fun stuff of campaign contributions and financial disclosures and government ethics? Okay. Mayor, would you like to take a short break, or would you like me to continue?
Let's take a break at 3:26. Thank you. Resuming at 3:30.
Thank you, Madam Mayor. So continuing our AB 1234 training, we do pull the Brown Act out and do it as its own separate item, only because we tend to get the most questions about that one. But we do have several other topics to discuss during our mandatory 2 hours together, and we will be going over those now. So this is our AB 12, I need to find the cursor, there it is. Our AB 1234 training agenda. Our session objectives are to familiarize you with the laws that govern your government service and when to ask questions. I didn't do it because you miss an opportunity to make a dramatic kind of a moment, and I always like to take this binder and then drop it and say, these are not all of the government ethics laws that you are subject to. This is just the summary. The laws that you're subject to take up a fair portion of my office. And so just to kind of get our expectations in order for the conversation, this is a broad 30,000 foot overview of the ethical requirements that public officials are subject to. No one expects you to be experts on every little circumstance. When an issue comes up, exactly what the right call is. My advice is, when you have an ethical issue, two things. If you're in doubt, feel free to recuse yourself, okay? And number two, if you're in doubt, ask for legal advice. The city has retained me and my firm to give you legal advice. Please take advantage of it. So keeping those things in mind, I also want to encourage everyone to think beyond the legal restrictions, although I am here to discuss what the legal requirements are. But frankly, just like we talked about with the Brown Act, if you look at what the purpose of the law is, and if all of your actions are directed towards that purpose, you're rarely going to find yourself in hot water. And then lastly, the purpose is to help you comply with your mandatory AB 1234 requirements. Public service ethics is different than the ethics we follow in our daily lives. Laws play a big role. Perception can be as important as reality. That's something I've heard council members say to me. It's not just what a judge may think, but how would, if the facts of this came to light, look in a newspaper article? Would people view me as an ethical public official? Key concept, actions and decision makings must be in the public interest. If we follow that, again, I think we'll do okay. It's a 2-hour session, including the Brown Act training that we just did. We do have to follow specified content. We do have to ask questions, and proof of participation will be provided by me and the city clerk. So you see, I kind of do this every time. We always ask the question, right? So what's the Brown Act? In this one, I'm asking, what are ethics? And I know this isn't necessarily a full participatory training, but if anyone wants to give it a shot, feel free to do it. Otherwise, I'll just tell you the answer. I guess we can do it that way. How I've defined it, I think the difference is best seen as the difference between ethics themselves and the ethic laws that I'm training you on, right? So, because they're not the same. Ethics are what we ought to do. Ethics laws are what you have to do, right? So I'm training you on the things you're required to do, the minimum standards that the state has imposed upon government officials in the state of California. It isn't necessarily equal to how we ought to behave, right? There are civil and criminal penalties for violations of ethics laws. There are no civil and criminal penalties for violations of just general ethics. But I mean, I think that public trust and confidence is vital to the functioning of our public institutions, and so I know that even while sometimes when we get into some of these laws and have them actually applied to us, they do feel like a burden. By following them, including, disclosure requirements, it enhances the public service for the benefit of all of our residents. And so, like I said, we're going to look at the laws as a floor to conduct, not a ceiling. Keep in mind that just because a given course of conduct is legal doesn't mean that it will be perceived as ethical. And what I always recommend is a 3-part test, right? When you're faced with an ethical dilemma. And that is, 1, what, if anything, does the law say about this? It's a good place to start, since I'm a lawyer, right? What's the floor? Number 2, is that given course of conduct that you're considering, is it consistent with your own values and analysis of what would constitute ethical behavior, right? So just because something is maybe legal, maybe it's not how you would view as ethical. And then number 3, what is the public's perception of the conduct? And again, I get back to how would this play out on the front page of a local newspaper, okay? So moving on to what we ought to do, I think that this is always guided by what our values are. And these are the values that I've heard expressed here in Canyon Lake. We want to, as public officials, be trustworthy. We want to be loyal, responsible, respected. We want to be fair to the people who come in front of us, and we want to be compassionate. And we have a responsibility as public officials to make decisions for and on behalf of the public, not for and on behalf of ourselves or for and on behalf of any particular special interest. As city council, you're stewards of the taxpayers' resources. You know that. I've seen you battle with that very issue every time we're talking about when we're in budget season. And I think that we do have to recognize that in the area of governmental ethics, perception does matter. Like I said, just because something may be technically legal, if the public would view that unfavorably, that can have just as much harm to the trust in the government as a legal issue would. And then again, there's the personal and organizational ethics difference that we talked about. There's your own ethical standard, which you should follow. And then there's the one that is imposed upon you by the state. So let's dive right in to what those ethics laws, talk about what they cover, and discuss when we need to ask questions. But unlike the last time I did this, I put the consequences at the beginning of this particular presentation because, I think it's important that we understand what happened, like how serious this is taken, in our democracy. So there are criminal penalties for violation of these ethical rules. And it can be anywhere from 6 months. Like we said, we were talking about the Brown Act. Flagrant violations of the Brown Act may land you 6 months if it prosecuted as a misdemeanor. But there are violations of these other public ethics laws up to 20 years in prison. Civil penalties, fines of up to $250,000, restitution to the public agency, forfeiture of office and of any monies that were improperly gained, attorney's fees up to $1 million plus in some of these cases. You have to pay your own attorney and you have to pay others. And one of the things we'll talk about is it isn't necessarily the case that when accused of an ethical issue that the city will provide a defense. The city will have to go through a very specific analysis as to whether that will happen. You may be out of pocket looking at these things. And then finally, the personal cost, your personal reputation, and holding the office yourself. There are 4 categories of state ethics laws that we're going to go over. Those include personal financial gain. So these are things like bribery, self-dealing, employment, personal advantages and perks, compensation, use of public resources, gifts, government transparency. So you'll see Brown Act there. We've already covered that. But also financial disclosure. These are the forms that the city clerk's office has us fill out and post online. Public Records Act. We'll talk about the Public Records Act a little bit. I know sometimes people have a lot of questions about that. And then fair process. So we're talking about being fair in your decision making, being fair in our contracting, and being fair in our employment. Personal financial gain. So we're going to be looking at the prohibitions against receiving favors and money for your official actions. We're going to talk about stepping aside from the decision-making process when you have an economic interest in the outcome. And we're going to talk about the restrictions on employment in certain capacities after leaving public office. When we're looking at personal financial gain, the principle underlying these laws is that the possibility of personal financial gain or loss should not be a factor in your decisions as a public official, right? The public's business should be conducted for the benefit of the public, not for the benefit of any individual. And the laws in this area are designed to promote general ethical values of responsibility and trustworthiness. Public servants have an obligation and a responsibility to act in that public interest, and the public needs to trust that you will. So I think when we're talking about different kinds of financial gain laws, the one that comes up, I think the biggest one, I think, is bribery, right? So, let's just cut straight to the chase, right? Because this is the big one, right? It's the most blatant and extreme form of using your public position for financial gain. And bribery, and just so we have a definition here, involves conferring a benefit on a public official to influence that person's vote. And so what we have here is a situation where public officials cannot solicit receive or agree to receive a benefit in exchange for their official actions. So just because you didn't actually get paid to vote a certain way on something or to talk to a certain person in your capacity as a council person, even if you just asked for it, or even if you maybe agreed to receive it but never actually followed through, you're still going to have trouble under this section. In addition, beyond bribery, there's other forms of graft, including extortion. So that's getting something from someone by wrongfully using your public position. Sort of the opposite of a bribe, right? Bribe obviously is a bad thing, but it sort of, has there's a consensual aspect to it, right? Whereas extortion, a public official would demand money in return for performance of his or her official duties. So that could include demanding campaign contributions in exchange for performing action in one's official capacity. And then lastly, public officials are also forbidden from receiving a reward for appointing someone to a public office or performing the duties of their office. And so this is what you saw with Governor Blagojevich out in Illinois, right? Was essentially putting a Senate seat out to bid. Who wants it? Who's gonna pay me the most? And that's how that gentleman got in trouble and served federal prison time. Beware of the this for that, or the infamous quid pro quo, which has become a part of our political vocabulary in the last couple of years. I think that it's very common for people to perhaps make campaign contributions, and perhaps they may hope to have access or something, and that seems relatively common. But you got to really watch out for the implication where there's an understanding that something's going to happen, even if it's not necessarily expressly stated. Again, when you get into some of these areas, you may not have a technical violation of the law even, but if there's the appearance, it may erode the public trust. One of the pieces of advice I always give to brand new public officials is to think about what you're going to say when someone approaches you. The truth is, I'm not a city council person, right? I don't know how often people would approach public officials and try to curry favor or make some kind of arrangement, right? But I would certainly have already practiced in my mind how I would respond to that. Because it seems like it could be a very deer in the headlight situation where it's just, you're so shocked that something like this is happening, you may not know exactly what to say. So I recommend thinking about it. And then because, we kind of wanted to talk about all the bad things that can happen when for bribery, include up to 4 years in state prison. It can be much longer under federal law, depending on the circumstances. Loss of office, barred from ever holding office again, fines and restitution, paying the money that was taken as a bribe to the public agency, for example. And then, like I said, federal prosecutions, I don't want to go into this, I don't want to scare anyone, too bad, but it can be much, much worse. Yes.
The councilman, or former councilman that they're got him up now for lying to the FBI, why was the FBI brought in on a bribery case in the city of Los Angeles?
This is a good question.
I mean that's
here's-
a federal crime.
I'll tell you why it's a federal crime. If your city takes more than $10,000 from the federal government, anything you do can be subject to the federal corruption laws and ethics laws.
Okay, that makes sense.
And I defy you to find one public agency that doesn't take $10,000 of federal money in some way, shape, or form, through CDBG money, through other grants. And so the truth is, the feds have a hook. And one of the federal government's and the FBI's primary missions is local corruption. And the reason for that is that they feel, rightly or wrongly, that if there is corruption at a local level, your local law enforcement may be compromised by that corruption. And so they take a special interest, and that's why they have things like the Joint Task Force and public integrity units and things like that.
Okay.
What I would say in addition to this is don't count on a code of silence. Faced with the temptation to have a bribe or to have one of these other situations, I think it's easy to underestimate the chances of being caught in these circumstances. I think that there is a likelihood that people say, well, who's going to know? What's going to happen? I think bribery is actually relatively rare, which is why people think that prosecutors never find out. But the truth is that it will get out eventually. Prosecutors will learn about it from informants within the agency, people who feel pressured to make decisions, the co-conspirator, for lack of a better term, if they're engaged in criminal behavior in this way with a public official, they're probably engaged in other criminal behavior, and they will eventually get caught. And then they will turn on the public officials who they were doing business with, because the feds would love to root out that kind of corruption. So I'm just saying, not that this council needs to hear it, but I think it's important that, people think that these things will just, be gone and forgotten, but they don't. They do get out. Moving on from bribery, we'll talk about no self-dealing. So, this is less of the you scratch my back, I scratch your back, and now we're more into the I will scratch my own back, thank you very much. And we'll also talk about special rules for contracts. But, when we're looking at these things, we're primarily looking at two different sources of state law that kind of guide us. So the first one is going to be the Political Reform Act, which is governed by FPPC, Fair Political Practices Commission. So we look at FPPC regulations. So there's two sides to FPPC regulations. There's obviously the forms that we fill out for disclosure, and we'll talk about those in a bit. But there's also disqualification based on financial interests. And the general rule here is that look, there used to be an 8-part test, 8-step test. Now there's a 4-step test that was supposed to be simpler, but it's actually just as complicated as far as I'm concerned. But if you follow the simple rule, which is that as a public official, you may not participate in a governmental decision that affects your financial interests. Say it again. As a public official, you may not participate in a governmental decision affecting your financial interest. If you follow that general rule, or at least, look out for instances where it may be implicated, I think you'll find that you'll stay out of trouble pretty easily. And the rule is designed to have public officials avoid putting themselves in a position of having to choose between advancing their public interest that they were elected to advance and their own financial interests, because it's a conflict of interest. And the truth is it's hard, right? I think it would be very, very hard to be asked, to look at a specific instance that would have a public official may not make, participate in, or influence a governmental decision that will have a reasonably foreseeable and material financial effect on the official's immediate family, or any of their economic interests, right? So there was a lot going on there, and let's just break it down real quick. So first of all, may not make, participate in, or influence. So once you know that you have a financial conflict of interest, right? Stop, right? Don't talk to any of your council members about your thoughts on that topic. Don't talk to staff and try to influence them, except to tell them that I'm disqualifying myself and recusing. You're proposing a public works project that comes right down my street, I'm out, right? Don't say, you're building a public project that comes right down my street, fantastic idea, I'm out. I could see myself saying something like that. Don't say it, right? Leave it alone. The city staff will know that they should not discuss it further with you. And then, if one of your colleagues wants to talk to you about it, simply let them know, that implicates a financial interest of mine, an economic interest of mine, and I'm going to have to disqualify myself and not talk about it. And then the next one is reasonably foreseeable and material financial effect. Whew. So clearly a lawyer wrote that because it uses the word reasonably and foreseeable and material, all of our favorite words. And essentially this is the part where, frankly, when we get down to it, it's the kind of thing where maybe you tag in the city attorney's office or the FPPC. There are tests for when is something, reasonably foreseeable or material. There are significant lists of what's a non-interest, what's a remote interest, and the fact of the matter is it's too much to go into in a short training like this, except to say those exceptions do exist, and if they're applicable, I will let you know, or the FPPC will let you know. But the big thing that I want for coming out of this training is just to be aware of the kind of interests that are at play here, so that when you see something come up, you can ask the city manager or you can ask me for assistance. And then lastly, the official's economic interests. And so what are economic interests, right? So I already said one, real property, right? Everybody knows that if the city decision is going to affect the value of your real property in a significant way, and more than it affects the public generally, that you probably need to recuse yourself, right? So building a street, redoing the street in front of your house, right? Probably important. The FPPC used to have a bright line rule, right? They used to say 500 feet, okay? If it's within 500 feet, recuse yourself, disqualify yourself. If it's outside that, you're fine. But then they started to get circumstances where your property's value can be significantly affected by a decision happening 2-3 miles away, right? Some of the members of the city council now or have served on regional transportation commissions, right? So I'm going to give you an example. There was an individual who owned a significant amount of property, 120 acres, okay? It was about 2 or 3 miles from a freeway, but there was no exit, right? So the property, had its value. Its value was what it was. The Regional Transportation Commission was deciding whether to build an interchange, an off-ramp, an on-ramp, right? About 2 miles away from that property. Now all of a sudden, this property, which was kind of out in the middle of nowhere, now all of a sudden was going to have ready access to an interstate freeway, right? Now, even though it's relatively far away, that property's value was looking at significantly increasing. And that public official decided to recuse themselves and honestly sent a request for an opinion to the FPPC. And that's when they realized, we got to have a better rule than just 500 feet, okay? Other things besides real property, sources of income, okay? And that can be in the form of employment. That can be in the form of another person. That can be in the form of a business entity that will be affected by a governmental decision. Or it could be in donors of gifts, right? So if someone is regularly giving a council person or another elected official gifts, and this decision will negatively or positively affect them, that could be an economic interest. Just going back to a second, talking about that disqualification, right? It's not just stepping aside from voting. It seems to me, just in my line of work, that usually I get involved. I'm informed of something, usually, in anticipation of a board meeting, when something's on the agenda. Hey, this thing's on the agenda. You know, should I participate, or should I stand up and walk out of the room? And what I want you guys to be aware of is it's the entire decision-making process. So it's from start to finish with city staff, being involved in that process if you have a financial interest. Includes conversations with fellow officials, includes conversations with staff. We've already sort of talked about this, but let's go into a little bit more detail. Sources of income. Receiving $500 or more in income from a single source, including any business, any nonprofit organization, any government entity, any individual within the 12 months prior to the decision, not calendar year, 12 months prior, creates an economic interest. It can include a community property interest in a spouse's or domestic partner's income, right? So there is an exception there if your spouse works for a public agency, by the way. So if you have that, make sure we look into it. Additionally, if a person promises an official $500 or more in the 12 months prior to the decision, they're a source of income even if the income hasn't actually materialized yet. Investments, an economic interest is created when the official spouse, or the domestic partner, or dependent children have an investment worth $2,000 or more in a business entity. And it can include stocks and corporate bonds, although not government bonds. Businesses, if you're a director, officer, partner, employee, or otherwise in a management position in a company, an economic interest is created. Special note here, does not apply to the member of the board of a nonprofit entity, right? So that will sometimes come up with CDBG grants, things like that. Personal finances, an official has an economic interest in their own expenses, their own income, assets, liabilities, and that of their immediate family. Business-owned property, loans, gifts. Again, we talked about gifts. And last point before we move on, I think I mentioned it earlier, the timeline for determining, when that economic interest exists is the 12 preceding months, right? So, income from 3 years ago doesn't count. There was a story of a person who was considering running for mayor in a relatively large community. That person owned an automobile dealership, and we'll get to disclosure again later. But one of the things that person had to face was, do I have to disclose every person I've sold a car to in the preceding 12 months as a source of income? Realtors face this. Do I have to disclose every person that I've sold a house to? Right? I already sold them the house. There's no more business to be had here. I've done my job. Do I have to disclose that? Is that going to affect my ability to do business throughout the city? Disqualification versus abstention. So I always put this in here only because as a attorney, I like precise terminology. I like to know exactly what we're talking about. The terms abstention and disqualification get used interchangeably, and they're really not. The important, and just to be clear though, just because you use the wrong word doesn't mean you're going to get in trouble. I just think it's important to know what we're talking about, and so hopefully we can use the correct terminology going forward. So when we're talking about abstention, this is voluntary, right? Abstention is voluntary. It's an instance where a public official voluntarily chooses not to participate in a decision-making process. They are abstaining from that process because they know it will be difficult to put a personal interest aside, but there is no legal requirement to do so, right? Or there may be a legal requirement, there may not be, but the public official is not sure. So they're going to abstain. The decision to voluntarily refrain from participating can involve the fact that you're honoring your own ethical standards. Remember what I said before, 3-step process, right? What does the law say? What do my own personal ethics and convictions say? And what does the public interest say? If the reason that you can't participate is because of number 2, then it would be appropriate to abstain. Disqualification, on the other hand, is when the law says you can't participate in this decision. You are disqualified from participating in the decision. And so that is what we will note when we're talking about it. You are disqualified because of a particular conflict. And then the last thing, I don't have a slide for it here, but I do think that, no, never mind, we do have a slide. Sorry, I have a preview here. Mostly I'm going to talk about what to do when you are disqualified, how to leave the dais, things like that. Getting advice. So again, we're doing a 30,000 foot view here. I know it's been kind of slow going in the initial part of the ethics. We will speed up as we go through the other 3. But the important part is to know when you have an issue, right? You may not always know what to do about it. That's what the city manager is for. That's what I'm for. That's what the state FPPC is for. You can certainly get ethics advice from them if it's within their jurisdiction. And the 2 easiest options are agency counsel, so your city attorney. Relatively easier to obtain. I am at your beck and call, of course. If you have an ethics question, I will give you my best efforts to answer whether I think you should disqualify or not. So in that sense, it is easier to obtain than FPPC advice, but I cannot confer you immunity. So if I am wrong, right, and I do not have an ego so large to think that it will not happen eventually, although it hasn't happened yet, that's me giving you the advice saying it's okay is not going to be a defense, unfortunately. I think it would be taken into consideration. But if you want immunity, you can ask the FPPC for their input on whether a disqualification exists or not. And FPPC advice letters are fantastic. I look to them, I look at the new ones that come out all the time, and that informs how I give advice. I look at how they're giving advice. Allow yourself plenty of time. It seems like it takes them months, if not years, to get the facts and then get an advice letter turned back around. It does confer immunity, though. If they say you can participate, then even if someone later says, no, you shouldn't have, you're not going to get in any legal hot water. I should note here also that the FPPC does have a hotline. I'm not aware of anyone who's used the hotline successfully, but it does exist, and feel free to try to go in that direction if you'd like to. If you are disqualified, so we already talked about number 1, do not discuss or influence either staff or colleagues. Number 2, do identify the nature of the conflict at the meeting, right? So if the decision is being voted on at a public meeting, verbally identify the financial interest or potential conflict of interest in sufficient detail to be understood by the public, okay? And so we've kind of talked about this before in other contexts, right? So investment, if it's an investment, right? Provide the name of the business in which the investment is held. If it's real property, give us an idea of where the property is, if it's, your home, you don't necessarily have to put the address out there, but you could say, I live on that street or I live on that block or something like that. Give us an idea of what's going on so that we know. If it's income, describe the source. And then number 3, leave the room. Okay? So there is an exception to this. If it's on consent, just simply say I abstain, and you can stay at the dais, and we'll vote along. But if it's an item that's being actually discussed, you need to walk out of the room. And then staff will let you know when that item is over, and you can come back and take your seat, and we can continue the meeting. Another exception to the leave the room is if the item that we're discussing relates to real property or other interests, like a business entity interest, and you would like to represent that interest as a member of the public would by approaching and speaking during public comment, you may.
Wait, say that again?
I piqued the mayor's attention. Very good. My monotone isn't working very well. So, if, for example, I'll give you a really good example because this is an actual thing that happened. The city is going to build a crosswalk. The city's going to build a crosswalk next to your house, right? You could say, oh, I don't want a crosswalk there for whatever reason, right? So but it's going to affect the value of my property. I have to disqualify myself. So you step down to the dais, but you can come up and say, as a member of the public, I would like to represent my property here, and I would like to tell you that I don't want this crosswalk to be put in. I have a huge note here that says, think about how that looks. It's literally what it says. But it is an exception that exists. Because the fact of the matter is, just because you are disqualified from participating here, right? If nobody's going to represent the interest of your business entity or of your property, that doesn't seem particularly fair either.
I have to send my husband.
Or yes, that works too. Let's see. Failing to step aside, what happens? The decision could be invalidated. It could potentially be a misdemeanor resulting in loss of office and inability to hold office in the future. Fines, $5,000 to $10,000 per violation. Attorney's fees, and of course the embarrassment of being wrapped up in a scandal. So those are the FPPC regulations. So those talk about financial conflicts of interest generally. We do have to discuss the special rule that exists for contracts. And you'll have heard this in the context, they're called 1090 issues, right? People say, it's a 1090 issue. City attorney will say, oh, it's a 1090 issue. What that means is we have a special circumstance when we're talking about interests in contracts. And this is one of the oldest laws in the state of California. And it says that a public official may not have a financial interest in any contract made by the city council in which that official is a member. And it's extremely strict. Okay? So if the city enters into a contract where one of the city council members has a financial interest in that contract, the contract is void. And here's the thing, it doesn't even matter if you disqualify yourself. Okay? Even if you stand up and say, this contract is with my firm, right? So I'm going to leave the room. You guys will do what's right, I'm sure. And you walk out. Even if the city council approves it, it's void, right? You cannot have an interest in a contract with the financial or with the government entity. And like I said, cannot be avoided by disqualifying yourself as a public official. That is not necessarily true for the public officials, such as the city manager, city attorney. Obviously, the city manager has an interest in the city manager's contract. I have a interest in the city attorney contract. This applies mostly to this side of the dice, the city council members. That doesn't mean that we aren't implicated as well. We do have to disqualify ourselves when our financial interests are implicated by a contract. Key things to keep in mind. It applies to all aspects of the contract, right? Preliminary negotiations, discussions, planning and solicitation, in addition to the approval of it as well. A financial interest includes a direct or indirect financial interest. Direct is pretty straightforward. It's when the official is the party that's actually contracting with the agency. Indirect is when the official has a financial relationship with the contracting party or is going to receive some benefit. There is a lot of drilling down that can occur here on where that line is. That's kind of beyond the scope of a general presentation such as this. But if you ever have a question, let me know, let the city manager know, and we'll talk about it with you. The next thing, so just moving on from financial interest in particular decisions and contracts, financial interest in future employment. And so this talks about the revolving door prohibition. And so, I've seen this in play in other agencies, where you have city council people, where you have top managers, where you have city attorneys, who leave office and then appear on that side of the room and start advocating for particular interests. And so the first rule is that a public official may not influence agency decisions when the interests of a prospective employer are at stake, right? So you don't really get, I understand maybe that's a little more difficult to see maybe in the local context. Let's talk maybe like a more obvious context. Let's say I work for the SEC, right? And I know that, a investment bank is looking to hire a regulatory attorney, right? I can't influence an SEC decision about that particular bank while I'm trying to get a job for there, right? And so in the same way, elected and appointed officials can't do the same thing in this context. And furthermore, you can't represent individuals or entities before the agency for 1 year after you've left office. Key things to remember before we move on to Section 2, which covers perks. Place the public interest above your own private interest. Your decisions should not be about the money, should not be about your money, the taxpayers' money. Now that's perfectly fine. So next group is perks. And I really dislike this section, mostly because I like the idea. I think we all kind of like the idea of perks, right? Who doesn't like perks? Perks are great. But perks, in the sense of the public official context and in the government transparency and ethics context, leads to potential issues of anti-democratic behavior, right? Especially where people are trying to influence governmental decisions through perks. And so we want to make sure that public officials aren't on one hand being perhaps pressured directly or indirectly through getting perks to vote certain ways, but on the flip side, giving the appearance, right, that they are. Your status as a public official is that of a public servant, right? And the public resources that go with this should not afford special status. There's two kinds of the no perks law, so I just sort of touched on one, which is things like gifts, comp travel. So that's one kind of perk. The other kind is the advantage that you all hold as incumbent office holders, right? And so this is the kind of thing we'll talk about, use of, for example, official government mail, right, for personal purposes. The idea is that we want to promote a general ethical value of fairness, responsibility, and trustworthiness. Perks undermine the public trust that you're treating everyone who comes before them fairly and decisions are being made solely in the public interest. And then secondly, on the second type of perk, when an office holder gives themselves perks of the office, the public trusts that the office holder is being a careful and public-minded steward of public resources is undermined. To the extent that some of those perks may give you a political advantage, it undermines the fairness of campaigns and elections.
That sounds like a lobbyist.
What's that?
That sounds like a lobbyist.
Well, I think that, a lobbyist, we're certainly getting into the areas of like, gifts and things like that. But I think when you're talking about what a lobbyist, their core function is to represent the interest of a constituent to an elected office holder. And on its face, there's absolutely nothing wrong with that. That is democracy. I think that where, people get sort of a negative impression of those kinds of activities is, where the lobbyist is taking public officials out, perhaps to an extravagant dinner, perhaps to entertainment of some kind. And it could give the impression that fairness in decision-making would be undermined. That being said, I think that the proper functioning of government requires public officials to communicate with people. And I mean, if we're going to do every single thing inside of a bland room with no food, it certainly takes the joy out of life. So I think that you do have to understand what the rules are, understand not only what the rules are, but what the impression of them is. Would the public be unduly concerned about getting coffee or a reasonable meal with another person to discuss public business? No, almost certainly not. Would the public have a concern, like I said, over an extravagant meal at a place that you would ordinarily never go to? Perhaps they would. And so the three areas of perks we're going to talk about again are compensation, use of public resources, and gifts. So the first one is talking about local official compensation. And so this is the sort of circumstance where local officials are receiving compensation in exchange for perhaps doing their official duties. So I think that the way people usually feel about this is, I got invited to come to this event. I was comped in a certain way. And I think in those circumstances, touch base with the city manager's office, touch base with the city attorney's office. If you're not paying your way on some of this stuff, it may give the impression that something is fishy. Use of public resources. So the most common one I deal with here is mailing. So use of, they're called franking privileges. It's sort of an old term here. And this is where, perhaps the city sends out mail on a regular basis to your constituents. I would say that this used to be perhaps a bigger problem than it is now, because I think most people communicate via social media, right? And there's no real cost to putting out an email blast. Things that I haven't seen anyone really push for is a decision on whether use of those social media outlets, use of an email blast, constitute any kind of significant use of public resources. To my way of thinking, there's very little cost here, but I think you could also look at it, it's sort of a be reasonable sort of situation. If council members are spending a lot of staff time, for example, or agency equipment to prepare these kind of things, that may move into the realm where your use of public resources would be prohibited. We touched on this a little bit, but public resources are money or anything paid with public money. So staff time, office space, equipment, supplies. Again, I'm not entirely sure how like a social media presence would factor in on this. The city doesn't pay for it, as far as I know. There's no cost to sending out an email other than, a thing that already exists. So would it be implicated? My recommendation would be to use the city's resources for the city's business. Obviously, communicating with your constituents is part of the public business, but it should be focused for those purposes. Reimbursement. We obviously have reimbursement policies here at the city, and one of the things that the city council did, I think very early on when I came here, was dramatically overhaul how reimbursements were handled to make it much more transparent and streamlined. And so I think that generally it's not an issue you guys have here. But, just keep that in mind, that we do have an expense reimbursement policy. It's recently been enacted by the city council. City clerk has copies of it, and you should follow it. This is what I sort of talked about earlier. Political use of public resources, and so mass mailing restrictions. And so when we're looking at exactly, how this, used to really implicate itself, it was the mailings that would go out. How many times can you mention the council member's name? How many times can you put their picture on? Can you put the name and the picture on it, right? And there are very specific rules for this, for mailings. I don't know, city manager, does the city even really mail significant things other than essential notices and stuff? Yeah, I think probably this city, operates mostly in the 21st century, and sends a lot of its communication out electronically. So it's not really something that's come up. But just talking about, what the penalties are for this, there are potentially $1,000 a day fines, and criminal penalties, going into 2 to 4 year terms. So we're going to move on to the thing that I think people actually have to deal with on a pretty regular basis, which is gifts. And so I like the title of this slide we put together. It says, "Gifts don't always have bows." And then you'll notice I specifically put a train on here as my picture, and that is because number 3, certain types of travel. Did you know that the California Constitution contains a prohibition on accepting free rail travel, specifically free travel by a railroad? This came up in a jurisdiction that I was dealing with, that there was a special train day, because there's a lot of cities that are along various railroad tracks. They have historic train depots. And the BNSF line that ran through brought in an old steam engine and was going to have a tour, right? And it was free to the public officials, or so it was seen. If you took that free train ride, even as silly as it was, just sort of going around, tooling around and coming back to the station, it results in the immediate forfeiture of office. And the rationale for that, just like the 1090 that comes from very early on in the state's history, is that the state was terrified of local officials and state officials becoming beholden to railroad companies, and accepting any kind of gratuity or gift from a railroad company, including free rail travel. But, the other things that are much more common include meals, food, drink, entertainment, so sports and concerts, and we've talked about that. The current gift reporting requirement for 2021, I looked it up before we did our training today, is going to be $520 per year. You report 50 and above. There are exceptions to certain kinds of travel and informational materials, and if you want some advice on whether something's exempt or not, then certainly reach out to the city manager, reach out to the city attorney. I have sort of, I always ask, I always have a couple of questions that you want to ask yourself, right? And so the first question is, did I or my family receive something of value? This came up in the context of a business that operated a suite at a local minor hockey league arena in the Inland Empire. And this particular business would invite people to come to their suite. And they'd give you a ticket. And, you come in, you get to go in the back entrance. You don't have to come in through the main entrance. You get to hang out in the cool lounge where they have, food and everything. And then you get to watch the sporting event in a suite. And the ticket said face value $0. And people would say, I don't have to report it. It has no value, right? Okay, what it says on the ticket is not determining what the value is, right? The value of something like that is what would a member of the public have to pay in order to obtain that, but not for this relationship that, whoever may have with this particular entity. And in this case, it was worth thousands of dollars. And so, so did you receive something of value? Don't fall for what it says on the ticket trap. Number two, what's its value? I just told you sort of how we compute it. What would any other person have to pay in order to receive that item? Next is, who gave it to me? Did the city give you the tickets, right? Because this is one of the things that cities are allowed to do. People are allowed to give the city, and by the city I mean the city manager's office, tickets for events. They can't tell the city who to give them to, but the city can distribute tickets under a ticket distribution policy. And that's one way in which, you may end up at local, it's usually like local sporting events, they want to see public officials and things coming to them, or they want public employees to have an opportunity to recreate, but it has to be pursuant to those ticket reimbursement policies. So who gave it to me? Did the city give it to you as part of your official duties? Did a business give it to you? Did I do something in exchange for what I received, right? Sort of a question on the sort of quid pro quo, right? Always keeping that in mind. What kind of a gift is it? Who do I have to report it? And then what are the permitted course of action if I can take with respect to the gift? So, one of the instances I've encountered is a public official who, again, received tickets. This time it was to a major league baseball team based in Orange County. Very nice tickets to the Diamond Club. And I was asked, I didn't want to say no, right? I didn't want to be rude. But I also don't want to report it, right? So I gave him to my daughter, right? No, no. So, if you're going to do that, you're going to have to report it, right? It's still a gift. What if you gave them to the public agency, right? What if you called them up and gave them back? What if you said, you know what? I don't want I really appreciate the thoughtfulness, but I don't want these. I'm going to return them to you. Thank you for the offer. These are all the kind of questions, and it depends on the kind of gift it is. And it's why you want to talk to the city manager, you want to talk to the city attorney.
What about fundraisers? Elected officials will get invited all the time to fundraisers to quote unquote fill the gap.
Right.
So no check is obviously written. It's just there to support.
Sure.
There's food, all that other good stuff.
Right. And so I think that it's subject to a rule of reason. There is a specific exemption for nonprofit fundraiser tickets. If you give me like 2 seconds, I can probably find it in my summary. Actually, I will. The exact exemption that we're looking at for that one. So the exemption for fundraiser tickets you can find at California Code of Regulations, Title II, Section 18-946.4. I'll be happy to send that out, but that is one of the specific exemptions. So again, this is exactly the kind of process that I think is really good for the public officials to go in, which is, city attorney during our training said, tickets can be bad. What should I do? Called city manager. City manager says, well, come on, fundraisers, that's pretty common. Everyone seems to go to fundraisers. There's probably an exception. And then, I get an email or a call, and like I said, what was that? 10 seconds? And I've got the exemption for you. So that's sort of the goal of the training, is to make sure we're all thinking exactly like you said. We've got about 15 minutes, so I'm going to pick up the pace, but feel free to stop me if there are any concerns. Gift limit penalties, up to $5,000 per violation, and your own attorney's fees. I put $3,000 to $30,000, but depending on the circumstance, it can be much higher than that. I put my special rule in here again, because I don't know why, I'm just obsessed with this. No free transportation from transportation characters, including railroads. Penalty, you will lose your office. Key thing to remember, don't rationalize the perks and the gifts. I think this is like one of the things that I see that's most dangerous and kind of insidious, is where you start to come up with a justification for these kind of things. Oh, well, I received this gift that was over the reporting limit, but, it resulted in a very big project coming to my jurisdiction, and it caused, significant amount of jobs were created for the people in my jurisdiction. So, on the balance, the public good was served. Just be careful of that kind of thinking, right? Because I think it's a slippery slope. And then lastly is, we are all aware generally of these kind of restrictions, but most members of the public aren't. They think they're being friendly. I know my grandfather, he used to have movie ticket vouchers. And it was just kind of a nice gift that, if someone did something nice for him, he'd say, oh, here's some movie ticket vouchers, as sort of a way to say thank you, right? You could go and take that and you could basically see whatever movie you wanted at a movie theater. And that was just a way of showing his appreciation. But for a public official, receiving things like that may be an issue. Group 3, so like I said, we're going to pick up the pace here because we've already covered some of these. This is about transparency, right? So these are questions of, okay, so we've talked about, the more issues of, doing things in your own personal interest. Then we've talked about perks. And so now we're going to talk about how does the public keep an eye on all this to make sure that we are following the rules. The principles are, what we do is the public's business. We talked about with the Brown Act. And number 2, the public trusts what they can see. So now we're going to probably get into one of the city clerk's favorite things, financial disclosure. 2, we'll briefly touch on charitable fundraising. And then we will do a swing by the Brown Act and the Public Records Act. I think the biggest one here is financial interest disclosure. And this is the part where I think, frustrates a lot of people. Transparency involves an obligation for high-level public officials to disclose their financial interests. You do this when you assume office, so I assume our new council person has received their assuming office statements. I just had to fill out some last week. You'll get them every year, assuming office statements, and then you also have to fill them out upon leaving office. I'm not going to really go into a lot of detail on the financial interest disclosure unless somebody has a specific question. These are primarily form-driven. The city clerk's office keeps a regular calendar of when the forms need to be filled out. A lot of you may have campaign treasurers who assist you in filling out the campaign side of the financial disclosures. The personal disclosure statements are usually relatively straightforward. They come with directions from the FPPC. If you ever have a question, you can always follow the rule of more disclosure is better than less disclosure. But the truth is, if you have a question, ask the city clerk. She may know. If you need assistance, you can always ask me as well. Charitable fundraising. This rule applies to elected officials, and this relates to how you are raising money for charity. One of the things that I've seen in other jurisdictions is I call it like a directed donation. It's where perhaps a city council person, oh, I don't need anything for my campaign account, but I would love it if you contributed to this worthy cause. That may result in the public official having to file a disclosure statement that you directed somebody to make a charitable donation, right? Brown Act, we spent a lot of time on the Brown Act earlier. No need necessarily, I think, to go into more detail unless there are additional questions. And then public records. I think we're all relatively familiar generally with the idea of Public Records Act. Every record of the city of Canyon Lake is a public record. There's only a question of whether it's exempt from disclosure or not. The biggest, I think, sort of movement in the law in the last maybe 5 years has been on the issue of text messages, on the issue of personal devices. And the Supreme Court of California acknowledged there's no easy answer to this question. if a council member is texting a constituent using their personal device, is that a public record? Maybe. And in the case of the California Supreme Court, they said yes. But, one of the questions that city said is, okay, well, how are we supposed to know it exists if it comes in? And let's say that we know it exists, but, you have a council person like, I'm not giving you my phone, my personal phone to go through. How is the city supposed to be able to respond to that? And the fact is, they're not easy answers to those questions. So, my advice in this area is always just to be judicious about creating records. If you, a phone call can be sufficient. But just be aware that your text messages may be records subject to disclosure. And certainly there are exceptions to that that could come up if a request ever came in. The other thing that I think has just been a dramatic shift here is the use of email. I think cities used to create a lot less records when the Public Records Act was created. But now, if you consider every email to be a public record, and I mean, emails run the gambit from, a well thought out communication to a third party that surely would be a record in any other day and age, to, as simple as, an email saying, hey, look at this, thanks, right? Something you wouldn't have been able to do 30 years ago without email. Is this really the kind of thing that we need to spend hours pulling and researching and producing? And the answer has been yes thus far. And so, it's always important for cities to establish policies on, email retention, right? So some agencies, they have it set so that emails get automatically deleted after 60 days, and therefore they're not kept in the ordinary course of business unless the city employee or official does something affirmatively to save it. And that's been how they've attempted to do it. I can say, here at the city, obviously, we've been blessed to not have too many outlandish public record requests. But those that we get that ask for all the records related to something, and the city clerk's office has to go and pull all the emails, all the electronic records, all of the agendas, everything, it can be burdensome, especially on a smaller city. The key things to remember there on the gift side is, insofar as we're looking at gift disclosure, who's going to know is a very risky line of thinking. I spoke about that earlier. It will always come out. And, when in doubt, disclose. Because you can't get in trouble under the law for disclosing too much. So if you're concerned about it, you can just put it out there. And then we'll wrap up. I've got 5 minutes left, I think. And I will talk about the fair process. So these are, how do we make decisions in a fair way? And we're going to talk about decision-making, contracting, and employment. Fair process. So this is something I think the council is familiar with because we have had a couple of due process type hearings. A variance for a land use decision is an example of one. And in those cases, while generally when the council is acting in a legislative capacity, which is how you're acting most of the time, there is no prohibition on you making your feelings known beforehand, saying, you know what, this is how I'm going to decide this thing, come hell or high water. But every now and then we have what are called quasi-judicial hearings, right? Very different from your ordinary legislative role. And that's when you're making you're applying the law to somebody, right? So legislative is you're coming up with the law, quasi-judicial, you're applying the law. And when that's the case, we cannot be biased in our decision-making. We cannot express our views prior to the hearing. And you can even have the instance where a personal view may cause a conflict of interest. It's not even a financial interest. And then we have the issues that's here as well, where we're talking about the potential for nepotism. And so, this is where, we're friends with people, And we're going to be making decisions in their favor based on that, not based off of applying the law. Fair process laws continued, incompatible offices. And so, this is just talking about competing loyalties that you may have between jurisdictions. Fair process also includes competitive bidding requirements. So, we have a purchasing ordinance. We have state laws that apply to how the public needs to engage in contracting. And the reason for these is to produce the best price for the taxpayers. Although I think if you drill down into some of these, what you'll find is that for a city of Canyon Lake size, it dramatically increases the cost for some of our projects. And I will defer to the city manager to list his grievances in that regard. The key thing to remember is to focus on the merits of the decision. Lastly, I've got some platitudes here that I filled up a couple slides with. Apply your values to public service. Trustworthiness, be truthful with officials, the public, and others. Be loyal to the city. Be loyal to the people of the city. Be responsible for the city. Respect, fairness, compassion. Accept the fact that there's not always an obvious right and an obvious wrong. Accept the fact that having financial interests doesn't make you a bad person. It just means, you're a person. And I would say accept the fact that you're sometimes going to get pulled in multiple different ways. And sometimes your values are going to conflict. Loyalty versus responsibility, for example. Ask questions when you don't know the answer. Encourage an organizational culture so that staff knows that their obligation is to do what's right. Create that culture of ethics at the top. Comes from the city council, and it goes and it permeates the entire organization. And yeah, that concludes the presentation. I'll work with the city clerk's office to make sure we have the proof of participation certificates, unless she already has them ready. And then we will get them on file. With 1 minute remaining, Madam Mayor, I ask if there's any questions. And I end my presentation.
Thank you for a very informative presentation. The next regular meeting will be Wednesday, February 3rd at 5 p.m. for closed session and 6:30 for open session. It is 4:49 and we are adjourned.